Let's put our hands together again for Professor Olarinwaju. Thank you so much, sir. At this time, we will be inviting the Honorable Justice B.B. Kanyip, PhD OFR, who will be giving his opening remarks and a presentation. Honorable Justice Benedict Kanyip was appointed a member of the National Industrial Court of Nigeria from June 2000 to 2006 by the President, Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria. By virtue of Section 27 of the National Industrial Court NIC Act 2006, he became a judge of the NIC. The outcome of his research work has aided in policy formulation in the area of consumer law and practice. His research work on sales promotions assisted in the formulation of the regulations on sales promotions promulgated by the Consumer Protection Council. Honorable Justice, sir.
CIBN President, I understand, is our chief host. The host, President of Association of Corporate Affairs Managers of Banks, the registrar who looks after us, members of council of CIBN who are here, distinguished participants, and my very good friend Kanayo, who at very short notice decided to come and see things for himself. I'm sure by the time we are through, he must be thinking of how he will put something on film. Thanks for coming. I want to thank the Association of Corporate Affairs Managers of Banks for the invitation to participate and deliver, to use the words of the invitation, a brief 5-minute remarks, and being available for questions and answers, and being available for a short question and answer session this 2024 ACAMB Stakeholders Conference. Your website is silent on whether ACAMB is a trade union or an association registered under Part C of the Corporate Affairs, Companies and Allied Matters Act. All it states is that you were founded in 1996 by pioneer communication professionals through encouragement by banks' chief executive officers with a joint purpose of collectively changing the not too positive perception of the industry back in the day and restore ethics and public confidence in the sector. Your invitation letter to me acknowledged the strides made in the banking and financial industry, as well as the challenges inherent in catering to the diverse needs of banking customers, and then stated that the banking industry owes much of its success to your collaborative efforts as an individual. That's they were referring to me now. And as president of the National Industrial Court. Since my background straddles tax law, consumer protection and labor law, and given the theme of the conference, I do not know if the 5-minute remarks expected of me should be restricted to labor issues, or I should, in general, in my remarks, or I should be general in my remarks. I choose the first to be general and then more specific to the world of especially banking work. Banks, alongside other financial institutions, are critical to development. And so financial services are the core of any economy. They provide the infrastructure needed to develop other markets. Banks provide credit to economic actors, and insurance business creates a safer environment in which commerce and industry can develop. Investment services, which may be provided by a bank, insurance company, or some other financial institution or advisor, completes the tally. As strategic as the financial sector is, its stability must be ensured and financial inclusiveness elevated to a right. But the banking sector suffers from a number of practices which call for concern. A few examples will suffice. 1. Automation of banking services. As useful as this is in making banking business more convenient for customers, comes with it so many hidden charges. I often wonder why my bank, I won't tell you the name, sending me an alert relating to a transaction should charge me the cost of sending the alert. When I send an alert to a friend, I bear the cost. Why should my bank not bear the cost of alerts and charge them as cost items in its banking business, which would then qualify as deductible expenses for tax purposes? The same may be said of the account maintenance charge I get every month from my bank and upon which value-added tax is deducted. How is my account maintained to warrant this charge? 2. The practice of giving employees targets in sourcing for deposits. This in itself may not be a problem, though it is often a nuisance to those of us that are contacted for such deposits. The problem, however, is when those employed and given targets are in the main female employees. Aside from this, raising issues of discrimination in the workplace, especially where male employees are not so employed. The fact that it is female employees who often dress seductively that are unleashed on the unsuspecting public is a cause for concern. I must admit that in recent times, this practice is on the wane. 3. The practice of concentrating on short-term financial investments as against long-term and real sector investment. Financial markets need to become less, not more efficient. This sounds like heresy. The problem with financial markets today is that they are too efficient. The financial sector has become more efficient in generating profits for itself in the short run. Given the liquidity of their assets, the holders of financial assets are too quick to respond to change, which makes it difficult for real sector companies to secure patient capital that they need for long-term development. The speed gap between the financial sector and the real sector needs to be reduced. This means that the financial market needs to be deliberately made less efficient. The financial sector has grown much faster than the underlying economy. The very liquidity of financial assets makes them potentially negative for the rest of the economy. Unlike real sector assets, financial assets can be moved around and rearranged in seconds. Financial capital is often impatient and seeks short-term gains. Exactly because finance is efficient in responding to changing profit opportunities opportunities, it can become harmful for the rest of the economy. Coming more specifically to the world of banking work, I must preface my remarks with the fact that the third alteration to the 1999 Constitution, in coming with a new labor jurisprudence, to use the words of His Lordship Sirajo, is a game changer. His Lordship would go further to elaborately state, and I quote, "The court takes judicial notice of countless labor-related animosities which may hamper industrial relations if left to fester." Hence the enactment. The contemplation of the drafters appears more in their preference for the lower court, the National Industrial Court, to take a proactive stance in ensuring that the nation will not be left out in the reckoning of the Committee of Nations in the area of robustly flourishing labor practices and industrial relations. The court hereby reiterates that the clarion call is to the stakeholders in labor and industrial relations to strive in order to conform with the international best practices as obtainable in the field. Unquote. These words, though general to the world of work, applies with stronger force to the world of banking work. Hence, His Lordship Oguwumiju JSC would in a recent decision of the Supreme Court, Skybank PLC versus Ade concur in the following words, and I quote, "The new jurisprudence in labor relations cannot be ignored as the law is not static. The circumstances of each case and the motive of the employer is now a considerable factor in cases of wrongful dismissal. The new labor jurisprudence with the third alteration to the 1999 Constitution and provisions of the law in that regard, particularly Section 7(6) of the National Industrial Court Act, mandates that every court in the land shall have recourse to good or international best practices in labor or industrial relations. There is no doubt that the policy of the legislature to introduce new labor relation principles and international best practices into the adjudication of law in employment and labor relations is yet a fluid policy, merely pointing the judex to the new road to follow. There must not be confusion." Unquote. Last year, the same Justice of the Supreme Court, in a matter the cause of action of which arose in 1995, long before the third alteration came, and dealing with the issue of restructuring exercise, in a concurring judgment, was quite specific in saying that it is therefore in the best interest of employers to follow the letters of the law and international best practices where applicable in the disengagement of their employees based on redundancy. For us then at the National Industrial Court, we have long recognized that the banking sector is a sensitive sector, and so extreme care must be taken as to how its employees are treated. Accordingly, the termination of the employment of a bank employee with immediate effect suggests some wrongdoing, which the bank must justify. If the termination is to be upheld, if unjustified, the termination would attract more than the common law measure of damages, i.e., payment in lieu of notice. This viewpoint now has support, at least, of the concurring judgment of His Lordship Oguwumiju JSC, Skybank PLC versus Mr. Adedokun Olusegun Adegun. Actually, the decision was given in February of this year. Additionally, over time, we have been able to strike down a number of banking practices given our jurisdiction and power over the application of ratified international labor standards and unfair labor practices. I'll give a few examples. 1. Given that an employee has the unfettered right to resign, relying on Section 34(1)(c) of the 1999 Constitution, Section 73(1) of the Labour Act, and the ILO Convention concerning forced or compulsory labor, Convention 29, which Nigeria ratified on 17 October 1960, we have ruled against what we call the Unity Bank Clause. The name is actually named after a case brought against Unity Bank, which found in that clause found in some employers' conditions of service simply states that you cannot resign if you are being investigated for a wrongdoing. So the Unity Bank Clause is a clause in the conditions of service where the employer reserves the right to reject the resignation of an employee simply because the employee in question is being investigated for an infraction. In any event, the rule that there is an absolute stroke unfettered right to resign finds support even in Section 306, 1 and 2 of the 1999 Constitution in terms of constitutional office holders. What we have done is to strike down such a clause as being an aspect of compulsory labor. In other words, once an employee says, I want to go, you need to release him. Otherwise, anything he does after that is compulsory labor. 2, we also struck down a practice of an employer opening a virtual salary account for a claimant and 17 other employees. We held that this virtual salary account should never be accepted in our employment and labor relations, as it is demeaning to the dignity of the worker or employee, and so offends Section 34 of the 1999 Constitution. With the virtual salary account, what happened really was that an account was opened in the name of the employer, but for the benefit of a number of employees who were simply giving cards to access the account. If you read the labor laws, employees are entitled to choose which bank they want their salaries to be paid into. 3, we not only assume jurisdiction over staff loans when banks give their own staff loans. One such is reflected in the conditions of service. We frown on employers recalling staff loans at commercial interest rates where the termination of services of an employee is for no fault of his. We've seen situations where a bank would give a loan to a staff, the payment period is over a period of 15 years, 2 years into it, for no fault, at least disclosed, we see a letter simply being written, your services are no longer needed. And because the employer has terminated the employee, he recalls the loan at now commercial interest rate and says, we are using your benefits to pay for the loan and hope that you will find a way, if it does not pay all, to fit in the balance. We struck down on such practices as being unfair labor practices. 4, we have also struck down as unfair labor practice a bank dictating to an employee where to invest his or her computed gratuity benefit. 5, further struck down as unfair labor practice is a bank unlawfully placing a lien on an employee's account or freezing the employee's account's domicile with it. Lastly, we have also held it to be unlawful the refusal by a bank to issue work reference in favor of the claimant. And when it chose to react, it stated categorically that it is not giving the work reference because the claimant is indebted to it. A reason that was false and misleading. So, while the categories of unfair labor practices are not closed, these have been given as illustrations of practices in especially the world of banking work have met the disapproval of the NICN. The disapproval is a product of the new labor jurisprudence that is with us now, which it is in the interest of the banks to learn and imbibe. And as the courts have enjoined employers generally, it It is in the interest of banks to conform with international best practices as obtained in the field. Thank you all for your attention.
Thank you very much.